Welcome to LexTalks Legal Topics Simplified, where the law is explained step by step for students. In India,
In India, that's right.
today we are diving deep into the Forest Conservation Act of 1980, a landmark piece of legislation safeguarding India's forests. It's especially relevant for you, our law students listening in. We'll unpack its aims and objectives, the crucial concept of prior approval for non-forest use, and how landmark judicial decisions have shaped its interpretation.
It's fascinating how this act, enacted in response to a surge in deforestation during the 70s, really marked a turning point. It signified a shift from viewing forests as merely state subjects to recognizing them as a national treasure, demanding a unified approach to conservation.
I'm curious about this shift. What were some of the driving forces behind this change in perspective? Was it purely environmental concern, or were there economic and social factors at play as well?
It was a confluence of factors. Of course, the ecological impact of rampant deforestation was a major alarm bell. Remember, forests aren't just trees. They are intricate ecosystems impacting everything from biodiversity and climate regulation to water security and livelihoods.
Right.
The 70s saw a surge in industrial expansion alongside growing demands for land and resources, putting immense pressure on our forests.
So the government realized that a piecemeal approach wouldn't cut it.
Yeah.
They needed something more robust, something that addressed the issue at a national level.
Exactly. The Forest Conservation Act of 1980 emerged as a comprehensive response to this crisis. It aimed to curb indiscriminate deforestation and ensure that any diversion of forest land for non-forestry purposes was a last resort undertaken with utmost scrutiny.
Okay, let's dig into that. We keep hearing this term non-forest purpose. For our listeners, can you break down what exactly it means under this act?
It's any activity that involves clearing forest land for something other than forestry activities. Think mining, establishing industries, constructing infrastructure, even seemingly small-scale activities like cultivating certain crops or setting up certain kinds of plantations.
So it's not just about massive projects. Even something like growing coffee or tea could potentially fall under this act.
That's right. The Act recognizes that even activities perceived as green can have a considerable impact on forest ecosystems if not properly regulated.
This brings us to the concept of prior approval from the central government. What's the rationale behind making this mandatory, and what does it signify in the larger context of forest governance in India?
It's a powerful tool reflecting a significant shift in power dynamics. Before the Act, states had considerable autonomy over their forest resources. The requirement of central government approval for non-forest use underscores the national importance of forests. It ensures a more unified and ideally a more environmentally conscious approach to decision-making.
So even if a state government believes a project is essential for their development, they can't just go ahead without the center's green light.
Precisely. The central government evaluates proposals considering factors like the project's potential ecological impact, the availability of alternatives, and whether it aligns with national conservation goals. This ensures that decisions regarding forest land aren't made in isolation, but are part of a broader, integrated strategy.
It makes me think of those intricate ecological webs we learned about in school. This act is like acknowledging that every action, even seemingly localized ones, has ripples across the entire ecosystem.
That's a great analogy. And this interconnectedness is at the heart of why judicial pronouncements on this act are so significant. They add another layer of complexity and nuance to its interpretation.
Ah, yes, the courtroom dramas. You mentioned landmark judgments shaping the act's interpretation. For our budding lawyers, can you highlight a few key cases that have left a lasting impact on how we understand this law?
Definitely. The Diversion case decided by the Supreme Court stands out as a game changer. It broadened the definition of forest to encompass any area recorded as such in government records regardless of ownership. This had massive implications, particularly for private landholders who suddenly found their property subject to the Act's regulations.
That must have sent shockwaves through the legal community. Suddenly, historical records were being scrutinized in a whole new light. It really underlines the importance of staying updated on evolving legal interpretations.
Absolutely. Another significant case, T.N. Godavarman Thirumulpad v. Union of India and ORS, clarified several aspects of the Act's implementation. It emphasized the need for sustainable forest management and the importance of balancing development goals with conservation imperatives.
And then there's the Mukesh Ali v. the State of Assam case, right?
Yeah.
That one clarified that certain Supreme Court directions related to actions against forest officers were to be applied prospectively, meaning only to actions after the judgment, not retroactively.
You're absolutely right. This is a crucial point for legal interpretation. It demonstrates how judgments can refine the scope and application of laws over time, impacting enforcement and legal strategies.
Okay, so we've touched upon the Act's origins, the shift in perspective. It brought about the concept of non-forest purpose and prior approval, and how judicial decisions have played a role in its evolution.
It's a fascinating journey through the legal landscape surrounding India's forests, and it underscores how this seemingly straightforward act is actually a dynamic, multifaceted instrument of conservation.
It really highlights the interplay between legislation, judicial interpretation, and, I imagine, on-the-ground realities.
What are some of the challenges in implementing this act effectively?
One of the biggest challenges lies in defining the boundaries of what constitutes forest and non-forest purposes. The Gadavarman case, while landmark, also created complexities. Determining whether a particular patch of land falls under the Act's purview can be tricky, especially when dealing with private lands or areas with a history of shifting land use. I imagine it can become a legal battleground with different interpretations and arguments being put forth.
Exactly. And this is where the role of skilled legal professionals becomes crucial. Understanding the nuances of the Act, its various amendments, and the ever-evolving body of judicial pronouncements is key to navigating these complexities.
It's like a giant legal puzzle, with each case adding a new piece to the picture.
That's a great way to put it. And then there's the question of balancing development needs with conservation goals. India is a rapidly developing nation, and there are constant demands for land and resources. The Act needs to be implemented in a way that allows for sustainable growth without compromising the integrity of our forests.
It sounds like a delicate balancing act. How does the Act address situations where a project might have unavoidable impacts on forest land?
The Act has provisions for compensatory afforestation. This means that if forest land is diverted for non-forest use, the project proponent is obligated to undertake afforestation on an equivalent area of non-forest land or pay for such afforestation to be carried out.
So it's not just a matter of saying no to development, but finding ways to offset the impact and ensure that the overall forest cover doesn't diminish.
Precisely. And compensatory afforestation isn't just about planting trees, it's about creating ecologically viable forests that can provide similar ecosystem services as the original forest land.
That makes sense. It's about recognizing the value of forests, not just as timber reserves, but as complex, interconnected ecosystems.
Absolutely. And this brings us to another crucial aspect, the enforcement of the Act. It has provisions for penalties for violations, including imprisonment and fines. However, effective enforcement requires a robust monitoring mechanism, interagency coordination, and public awareness.
It's like a three-legged stool.
Right.
You need the law, the awareness, and the enforcement to work together for true conservation.
You've hit the nail on the head. The Act, with its focus on prior approval, aims to prevent violations in the first place. But when violations do occur, there need to be consequences to deter future transgressions.
So what are some of the penalties involved? We touched upon imprisonment and fines earlier, but could you elaborate on how these are determined?
The Act lays out specific penalties for different types of violations, and these are determined based on the severity of the offense. For instance, felling trees without permission could lead to imprisonment for up to 6 months, while encroaching on forest land for commercial purposes could result in a much steeper penalty.
It sounds like there is a clear intent to make the punishment proportionate to the crime.
Exactly. And the penalties aren't just aimed at individuals. The Act also holds government departments and officials accountable if they violate its provisions. This ensures that everyone is equally responsible for protecting our forests.
I imagine that sends a strong message about the seriousness of forest conservation. It's not just about pointing fingers at private citizens, but ensuring accountability at all levels.
Precisely. And this accountability extends beyond just punitive measures. The Act also emphasizes the importance of restorative action. For instance, if an area of forest land has been illegally cleared, the violator might be required to undertake afforestation activities to restore the ecological balance.
So it's not just about punishing the wrongdoer, but also about rectifying the damage and hopefully deterring future violations.
Exactly. It's about recognizing that forests are a common heritage and that everyone has a role to play in their protection.
This makes me wonder about the role of future legal professionals like our listeners in all of this. Where do they fit into this complex landscape of forest conservation?
That's a great question, and it's a question that brings us to the heart of why we're discussing this act today. Law students and aspiring lawyers have a crucial role to play in shaping the future of forest governance in India.
They are, in a sense, the future guardians of our forests, armed with legal knowledge and a passion for justice.
Exactly. They can specialize in environmental law, litigate cases related to forest conservation, advise clients on navigating the complexities of the act, or even work with government agencies to strengthen enforcement mechanisms. The possibilities are vast.
It's inspiring to think about the impact they can have. They could be the ones arguing those landmark cases, shaping policy decisions and ensuring that future generations inherit a world where forests thrive.
And it's not just about courtroom battles or policy interventions. Lawyers can also play a vital role in raising awareness about the importance of forest conservation, educating communities about their rights and responsibilities, and advocating for sustainable practices.
It's a holistic approach, recognizing that legal expertise can be a powerful tool for positive change.
Absolutely. And it's an approach that requires a deep understanding of the Forest Conservation Act, its intricacies, its limitations, and its potential.
Speaking of potential, is there anything in the Act that you find particularly innovative or forward-thinking, something that might surprise our listeners?
One aspect that I find particularly interesting is the Act's recognition of the rights of forest-dwelling communities. While the primary focus is on conservation, the Act acknowledges the traditional rights and knowledge of these communities and encourages their participation in forest management.
So it's not just about top-down regulation, but also about recognizing the role of local communities in sustainable forest governance.
Exactly. The Act emphasizes the need for collaborative approaches, recognizing that effective conservation requires the involvement of all stakeholders, from government agencies to local communities.
It's like a web of interconnectedness with everyone playing a part in ensuring the well-being of our forests.
That's a beautiful way to put it, and it's a web that we all have a responsibility to weave and strengthen.
Well, I think we've covered a lot of ground today exploring the intricacies of the Forest Conservation Act, its historical context, its key provisions, the challenges in its implementation, and the evolving legal landscape surrounding it.
We've also touched upon the role of judicial pronouncements in shaping its interpretation and the potential for future legal professionals to contribute to the cause of forest conservation.
It's been an insightful journey, and I want to thank you for sharing your expertise with us today.
The pleasure was all mine. It's always a privilege to discuss this crucial piece of legislation, especially with an audience that's eager to learn and make a difference.
It's been an incredibly informative discussion. I feel like we've only just scratched the surface of this complex yet vital piece of legislation.
It's true, the Forest Conservation Act is a dynamic area of law. It's constantly evolving through amendments, judicial interpretations, and even changing societal perspectives on the environment.
And that evolution is what makes it so fascinating, especially for those entering the legal profession. For our listeners who are just starting their law school journey, what advice would you give them if they're interested in pursuing a career in environmental law, particularly in the context of forest conservation?
I'd say first and foremost, cultivate a deep passion for the subject. Environmental law, especially when dealing with something as intricate as forests, requires a genuine commitment to understanding the ecological, social, and legal complexities involved.
It's not just about memorizing legal provisions, it's about seeing the bigger picture.
Right. Exactly.
Right.
Read beyond textbooks, explore academic journals, research papers, and even reports from NGOs working on the ground. Attend seminars and workshops, engage with diverse perspectives. The more you immerse yourself in the subject, the better equipped you'll be to navigate its challenges.
It's about becoming a well-rounded advocate, not just a legal technician.
Precisely. And don't underestimate the importance of practical experience. Seek out internships with environmental law organizations, government agencies, or even legal firms that have a dedicated environmental law practice.
You get your hands dirty, so to speak.
Yeah. Yes. Real-world experience will complement your theoretical knowledge and give you invaluable insights into how the law operates in practice. And of course, never stop learning. Environmental law is constantly evolving, so stay updated on new legislation, judicial pronouncements, and emerging trends in conservation.
It sounds like a challenging but incredibly rewarding path, one that's crucial for the future of our planet. I'm sure many of our listeners are feeling inspired right now.
I hope so. We need passionate, dedicated individuals to champion the cause of forest conservation. The Forest Conservation Act provides a robust legal framework, but it's the people, the lawyers, the activists who breathe life into it, who ensure its effective implementation, and who ultimately shape the future of our forests.
Beautifully put. Well, I think we've reached the end of our deep dive into the Forest Conservation Act. It's been an enlightening journey, and I want to thank you once again for being such a fantastic guide.
It's been my pleasure. I hope our listeners have gained a deeper understanding of this crucial piece of legislation and are inspired to explore its nuances further.
And for all our listeners, whether you're future lawyers, environmental enthusiasts, or simply concerned citizens, remember that the protection of our forests is a collective responsibility. Stay informed, stay engaged, and let's work together to ensure that these vital ecosystems thrive for generations to come.
Thank you for listening.
And don't forget to subscribe to LexTalks for more insightful deep dives into the world of law. See you next time.
See you then.